Hello everyone, kumusta po kayo? I hope that you are all doing good. The Philippine immigration has been governed principally by Commonwealth Act No. 613 since 1940. That is for over 80 years now. There were piecemeal subsequent legislations, however, that were passed amending parts of the CA 613. An example of this is Republic Act No. 4376, which added the Balikbayan Visa for former natural-born Filipino citizens who were naturalized in other countries and now desire to live permanently in the Philippines. Questions keep on coming on whether there is now a new immigration law in the Philippines, and if so, what are the changes? For all these years, proponents of the move to update the Philippine immigration law have kept on introducing and reintroducing proposals in Congress. Just this year, the House of Representatives proposed and approved on final reading House Bill No. 8203, also known as the Immigration Modernization Act, to update what is seen to be an outdated law and to modernize the legal framework for the Philippine immigration policies. I was personally hopeful that the Philippine Senate would come up with its own version soon after that, and that a new law would eventually come out. Remember that the Philippine legislature is composed of two chambers, the Senate and the House of Representatives. Many have rejoiced with the approval of House Bill 8203, but unfortunately, it is not a law yet. Without the concurrence of the Senate and generally the approval of the President, it does not become a law. I said generally upon the approval of the President because the President has the power to veto an enrolled bill, which veto, however, can be overridden by the legislature. We will not go that far. Well, the good thing is that the modernization of the Bureau of Immigration is one of the priority projects of the current administration. Nevertheless, what changes can we expect from the proposed modernization of the Bureau of Immigration? Among the major changes is the reclassification of the immigrants and non-immigrants. Under the present law, which is CA 613, these are the classifications of the non-immigrants and the corresponding visas that are issued to them. If you are familiar with the 9A temporary visitor visa, it falls under this category. As proposed under House Bill No. 8203, the new classifications of non-immigrants will be as follows. If you notice, this is more comprehensive. The current 9A visa will be classified into A1, A2, and A3 visas, depending on the purpose. Please feel free to pause the video if you want to read the entire list. Now, for the immigrants, under the present law, there are two types of immigrants, the quota and non-quota immigrants. For quota immigrants, it is limited only to 50 applicants for each nationality per year. For non-quota immigrants, they are classified as follows. Under House Bill No. 8203, the classification of immigrants will be as follows. There still will be quota immigrants, and this time, the number of applicants allowed per year per nationality will be increased to 200. As regards the non-quota immigrants, the House Bill proposes the following categories. It still includes the Spousal Visa, which is also known as Marriage Visa. This is for the foreign spouse of Filipino citizens. Also included are the natural-born Filipino citizens who were naturalized in another country, their foreign spouse, and minor dependents, and this is known as the Balikbayan Visa. Please note that the Balikbayan Visa referred to here is not the same as the Balikbayan privileges under the Philippine Balikbayan program, which includes the visa-free entry and one-year stay privileges. To avail of the Balikbayan privileges such as the visa-free entry and one-year stay, one does not have to apply for a Balikbayan Visa, which is for permanent residency purpose. Again, you do not need to have a Balikbayan Visa for you to avail of the Balikbayan privileges such as the visa-free entry and 1-year stay in the Philippines if you are a Filipino citizen living abroad or a former natural-born Filipino citizen who was naturalized as a citizen of another country. It is noticeable that the classifications under House Bill number 8203 do not expressly include the special visas such as the Special Resident Retirees Visa or SRRV and the Special Investors Resident Visa or SIRV and other special visas. But there is a paragraph included in the House Bill which states that all other visas issued by other agencies and offices authorized to issue visas in accordance with existing laws, except the DFA, shall be implemented by the Bureau subject to requirements prescribed by the Commissioner. To my mind, those special visas are covered by this provision. We can note also that the House Bill does not expressly amend or repeal the laws upon which the issuance of special visas such as SRRV and SIRV are based and authorized. I hope that you have learned something from this video. Please feel free to share your thoughts in the comment section below. And if you haven't subscribed to this channel yet, please don't forget to do so and to hit that notification bell icon so that you will get notified of our future videos. Always remember, ignorance of the law excuses no one from compliance therewith. I will see you in my next video. Ingat po kayo.